Good morning. Who's on the iPhone?
Yes.
What's your name?
Jacob Bullock.
Okay. Okay. You're not driving, are you?
No, I'm not. In the car, but I'm not driving.
Okay, I'm gonna put you on mute until I'm ready to call your case.
You said it again?
Yeah, I'm gonna put you on mute until I'm ready to call your case, okay?
Okay.
Thank you. It appears Mr. Basiga is driving.
I'm actually just pulling over, Your Honor.
Oh.
Right now. Here we go.
Your client has not started his audio. I don't know if you can give him a call.
Right here, y'all.
Okay, Mr. Bullock.
Your Honor, he's trying again.
Thank you. Mr. Bullock, your attorney is here in the courtroom. My understanding is that we're just gonna give you a final pretrial and jury trial date. I'm assuming there's been no offer extended.
Correct, Your Honor. No, that's fine.
Okay,
Okay.
so we'll get you some new court dates and then you'll be free to go. We're gonna set your matter for a final pretrial. You'll have to appear in person, okay?
Okay.
Your final pretrial will be July 26th at 8 a.m.
Jury trial scheduled August 9th.
Jury trial will be August 9th at 8 a.m. Both will be in person at the court, okay, sir?
Okay.
You're free to go unless you have a question for me.
No, ma'am.
Thank you. Have a good one.
You have a good one.
Well, I saw, no, I thought I got a video another one. Well, I got it before you sent it in. Your Honor, for final pretrial, I have Mr. Calvin Brady, Mr. Don Lewis, and Mr. Skylar Whitaker. And Your Honor, I could just have a minute. I'll go check the hallway, make sure no one's here.
See Skylar Whitmore. Donald Lewis. And then Calvin Brady. Mr. Hayes is still connecting to his audio. Um, if you would like to proceed without his audio, that's fine. I mean, this is a motion hearing, so. Siga, can you hear me?
Yes, Your Honor. I've spoken to Mr. Hayes. He can hear everybody. So for all intents and purposes, I think since we're just receiving the court's judgment, we can.
There's no possible way he can hear us. His audio is not connected. I've called his name and he can't even respond, so he can't hear us.
All right, let me try this again.
He's here. On the record, in the matter of the people of the state of Michigan versus Calvin Brady, number 22-01606 SM, council appearance.
Where Your Honor, Andrea Lacey appearing on behalf of the people and Assistant Public Defender Sarah Donnelly on behalf of the defendant Calvin Brady, who is standing to my right.
Good morning, Mr. Brady, how are you? Today was the date that was set for a final pretrial. This matter was set for 8 o'clock. It's currently 8:28, and the necessary witnesses have failed to appear. So the people are moving to dismiss. I'm going to sign your dismissal now. It's going to be without prejudice. That simply means if the necessary witnesses later make contact the prosecution, they want to proceed, they do have the right to reissue against you. Do you understand that?
Yes, ma'am.
Do you have any questions today, sir? Okay. We'll get you a copy of this and you'll be on your way. You're all set. Thank you. On the record, in the matter of the people of the state of Michigan versus Donald Arthur Lewis, file number 16-03095. Council appearance.
Good morning, Your Honor, Andrea Lacey appearing on behalf of the people and Assistant Public Defender Sarah Donnelly on behalf of the defendant Donald Lewis, who is standing to my right.
Mr. Lewis, how are you? Did you get enough sleep?
No, my daughter.
Oh, okay. Oh, no. Hopefully she's okay. Today was the date that was set for a final pretrial matter was set for 8 o'clock. It's currently 8:29. The necessary witnesses have failed to appear. And so the people are moving to dismiss without prejudice. It just means that if the necessary witnesses later appear, they will maintain the right to reissue the charge against you, okay? As to the PA 53, that will also be dismissed at this time. Do you have any questions? No. Okay, we'll get you a copy of the dismissal and you'll be on your way. Thank you. You're welcome. And we're on the record in the matter of the people of the state of Michigan versus Skylar Austin Whitmer, file number 22-01491, council appearance.
Good morning, Your Honor, Andrea Lacey appearing on behalf of the people and Assistant Public Defender Sarah Donnelly on behalf of the defendant Skylar Whitmore, who is standing to my right.
How are you, Mr. Whitmore?
Not too bad. How about yourself, Your Honor?
Doing well, thank you. Today was the date that was set for final pretrial. The matter was set for 8 o'clock. It's 8:30. The necessary witnesses did not appear. So the people are moving to dismiss without prejudice. It just means again that if the necessary witnesses appear and they're ready to proceed, the prosecution can reissue the charge against you, okay?
Okay.
Do you have any questions?
No, I do not.
Get your copy of your dismissal and you'll be all set.
Thank you, Your Honor.
You're welcome. Okay, Okay, Mr. Besiga, does not appear that Mr. Hayes is able to get his audio up and running.
I'm not too sure what to do at this point, Your Honor. He's tried logging in and logging back in.
Okay, do you want him to, he could dial in? And that way he'll hear, we won't see him. But for the purposes of this, I'll allow him to dial in. The instructions should be on the blue sheet as well. It keeps alerting me that he's attempting to connect. There's something going on in his end that's not allowing the connection to go through. Or maybe he's not clicking the audio, because you have to click start audio and then the next step, and I don't know if he's doing that.
Right. I'll see if he's able to dial in, Your Honor.
Okay.
I don't know if he has the phone number, so if Mr. Bigelow can send that to me in a chat, that would be fantastic.
You there now?
Ah,
I
yes.
can hear you.
Damn.
Whoa, whoa, sir, calm down.
I'm sorry. Sorry about that.
This is really loud. Okay, we're on the record in the matter of the people of the state of Michigan versus Stanley Hayes, file number 22-00286 SD. Council appearance, please.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Morning, Your Honor. Brendan Besiga with on behalf of Mr. Stanley Hayes. We're both appearing by Zoom and a waiver in-person appearance.
Thank you. Today was the date that was actually set for a jury trial. However, there was previously a motion hearing on a motion to dismiss on the basis of a illegal search and seizure, which the court needs to render a ruling on. And I've had an opportunity to go over your motions again and your arguments at the time of the motion hearing, and to categorize, I think, the background. It doesn't seem to be disputed. There was a traffic stop on October 3rd, 2021 at approximately 2:30 in the morning. Officers made that stop based on a alleged traffic violation or defective equipment. Officers stated that they found the defendant to have bloodshot, watery eyes, slurred speech, and that he was emitting the odor of intoxicants. Mr. Besiga, you argue that the officers immediately, upon making contact with your client, poked their head into the car. They looked in the windows and started shining a light, and he was advised that he was pulled over for broken tail lighters, something to that effect. I think they were later able to determine that there was an issue with Mr. Hayes's license and he did not have insurance. However, officers questioned Mr. Hayes about how much he had to drink that night, to which Mr. Hayes allegedly said he had a couple of drinks at the bar. Ms. Lacy stated that the defendant then gave officers consent to search his vehicle. The officer, or at least one of the officers, attempted to perform the standardized field sobriety test, but were unsuccessful. Officers administered a breathalyzer test, to which it is undisputed that there was a consent for the breathalyzer test. Those results came back at 0.107. Mr. Hayes was later taken into custody and the vehicle was searched with his consent, but also could have been searched because he was taken into custody. Officers located an open bottle of Hennessy in the center console of the vehicle. The defendant, Mr. Hayes, was transported to Sparrow for a blood draw, and the blood alcohol reading came back at 0.111. Mr. Besiga, your argument is that the results of the breathalyzer are tainted because the officers failed to wait the requisite 15 minutes for observation before administering the breathalyzer, and that your client had gum in his mouth. You also made an argument about a lack of Miranda warning, an argument about the validity or the basis of the stop in and of itself. And your argument is that there was insufficient probable cause to arrest the defendant, and that your client's Fourth Amendment rights would have been violated. And then obviously the prosecution opposes those arguments. Based on the facts that's been presented both by you, Mr. Basiga, as well as by Ms. Lacy, I have no reason to dispute the validity of the actual stop. The stop was made apparently because of the defective equipment. That's a valid reason to make a stop on a vehicle at 2:30 in the morning. And so I'm going to grant your request to dismiss based on the validity of the actual stop. Now, as to the motion to suppress the breathalyzer, the requirement for administering a breathalyzer is very clear in the law, and it said the person may be administered a preliminary breath test or a breathalyzer because they follow the same legal basis. Only after the operator determines that the person has not smoked, regurgitated, or placed anything in his or her mouth for 15 minutes. The purpose of this 15-minute waiting period is to ensure that there is accuracy within the test when it's administered. We have, based on your argument, well, actually, I think it's undisputed that because Ms. Lacy also agreed that it was unfortunate that the officers did not wait the requisite 15 minutes. I agree with Mr. Basiga that the result would be tainted because they didn't wait the requisite time period. They also later determined that he had gum in his mouth, so we cannot ensure the accuracy of that test. So I will grant a request to suppress the breathalyzer result. However, that doesn't dispose of the case entirely, because now the court has to rule on whether or not there was sufficient probable cause outside of the breathalyzer results, which are going to be suppressed at this time. And here we have a valid traffic stop. We have officers making an observation that the defendant had an odor of an intoxicant. His speech was apparently slurred, who had watery eyes, and his eyes were bloodshot. And when they asked him, would you have been drinking? He admitted to drinking. He also admitted or granted authority, I should say, or consent to search his vehicle, and the officers located an open bottle of Hennessy in the center console. I think that his inability to perform the standardized field sobrieties may have something to do with his limited mobility due to his health or physical condition. Nonetheless, I think if we look at the totality of circumstances, there's sufficient probable cause for them to believe that there was that Mr. Hayes was operating under the influence, and he was then arrested, and he had a blood-dried Sparrow, which yielded results actually higher than his breathalyzer. So I do believe that there was valid consent. I don't believe that there was a violation of his rights by failing to Mirandize him before asking him what he had been drinking. Officers have the right during the stop, within reason, to ask questions as they're investigating, and they can do that when investigating a potential OWI. without giving a Miranda warning. That doesn't amount to be a search procedure or a interrogation that would require a Miranda warning. And so, although the court is going to suppress the results of the breathalyzer, I am finding that there is sufficient probable cause for the arrest, and therefore the case will continue based on that. With that being stated, I don't know if there was ever an offer extended on this, or if you would like to just get a new trial date.
Your Honor, if I may,
Offer extended.
So,
There was an offer extended on this. I can put on the record if you'd like.
yes,
The offer for Mr. Hayes is to plead guilty to an added count 2 of operating while impaired in violation of MCL 257-625(3). That is a misdemeanor punishable by up to 93 days, $300 fine, I believe, and 360 hours of community service. In exchange for that plea, the people would agree to dismiss the original count 1.
okay. Mr. Basiga, are you still there? Oh, there you go.
I am, thank you, Your Honor. I think it would be prudent at this time, given the court's ruling, to request if we can set this for a final pretrial conference and hopefully have it resolved at that time.
Okay. Final pre-trial is going to be semantics. I'm not going to require witnesses to be subpoenaed. They typically do not require officers to be subpoenaed for final pre-trials for OWIs. I will give you another date though, so that your client can discuss the ruling with you and consider the offer, and then we'll have a trial date set as well. I'll give you both at this, those dates at this time. We can do next week, July 19th, for final pre-trial. Does July 19th work for you for final pre-trial?
July 19th, final pretrial. Yes, yes, Your Honor, that should work.
Okay, that's gonna be the final pre-trial. And the final pre-trial can be via Zoom. Hopefully, Mr. Hayes has mastered how to start his audio at this time, but nonetheless, that can be via Zoom. And then the jury trial. Friday, August 2nd at 8 a.m. The jury trial will be August 2nd at 8 a.m. in person at the court. Mr. Hayes, do you have any questions for the court? Okay. He's shaking his head. He's muted, so I can't hear him. But I'm assuming he doesn't have any questions for the court.
That's fine, Your Honor. I'll give him a call after this, and we'll
Sounds good. Any additional
I'll
matters for the
talk to him.
record?
Nothing from the people, Your Honor.
Okay.
Thank you, Your Honor.
Anything for you? Thank you. You're all set.
Okay,
Mr.
take care.
Basiga. Thank you, Mr. Hayes. Mr. Nagel, are you here on the Hill matter?
Good morning, Your Honor. I am.
Oh, on the record in the matter of the people of the state of Michigan versus Catherine Elaine Hill, file number 22-00774 SM. Have your appearance, please, counsel.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. Matt Nagel on behalf of Catherine Hill, both of us appearing via Zoom.
Thank you. Today's the date that was set for except for sentencing. I do have a pre-sentence report. With a recommendation. Did you get that, Mr. Nagel?
We did, Your Honor, and I have had an opportunity to go over it in detail with Ms. Hill.
Are we in need to make changes, updates, or deletions?
No corrections, additions, or deletions, Your Honor.
Okay, Ms. Lacy.
Your Honor, just so the court is aware, the victim in this matter was not able to make it to court today. However, she did send an email to me that she would like to have me read to Your Honor.
Okay, great. You can do so at this time.
Okay, thank you. Hi, my name is Kylie Dragosick. I am the victim in the domestic violence case against Catherine Hill. In my opinion, these charges should be dismissed. This was nothing more than a messy breakup that went sideways that in reality is just a small, irrelevant thing, and Catherine does not deserve to have this on her record. If this was in my control, I would have dropped these charges months ago. I do not feel like I am or was in danger, nor is there any reason for a no contact order to be in place. I was not impacted by this episode in any major way, and she should not have to pay such harsh consequences for one mistake that was brought on by the events leading up to it. Our relationship had been extremely rocky leading up to what happened, and we had dealt with numerous mental breakdowns and verbal outbursts from both ends. Catherine does struggle with depression, extreme debilitating anxiety and panic attacks, and borderline personality disorder. That being said, I have known her for 6 years, and she is not a physical person, nor does she have a history of being one. I do not wish to see her punished for events that took place amidst a justifiable emotional breakdown. Charges should be dropped and no terms are necessary, in my opinion. Please consider me in your decision. Thanks, Kylie Dredd. Just for the record, Your Honor, I did speak to the victim in this matter before making an offer to Ms. Hill. Her tone at that time and the conversation that we had was the complete opposite of it. But this is the letter that she asked me to read to the court. So I did want to make sure that it was read because she is very important to her. But I also think that it's necessary to explain that the offer was made with her consent, her input, and that was all considered prior to this. This is not just something I chose to pursue on my own.
Thank you.
Yes, you're welcome.
Mr. Nagel, did you want to make allocution?
Yes, please. Thank you, Your Honor. We are going to ask that the court just honor the HIDA recommendation from the APA. I do note in the PSI, the recommendations that Ms. Hill would benefit from individual and group counseling to change her thinking with respect to the use of substance abuse and cognitive behavior. Additionally, the outpatient substance abuse services, domestic violence classes, and mental health counseling, which we concede would benefit Ms. Hill greatly moving forward. All of this can be supervised through HIDA. And it's also important to point out that the complainant concedes that this should not be on Ms. Hill's record. The legislature specifically left out of the HIDA statute that it should be limited to a certain number of times. HIDA is certainly appropriate for this situation. I believe the recommendation not to honor HIDA is because there was a prior incident in 2017. However, that conviction is 5 years old. Ms. Hill has not had substantial contact with the criminal record since 2017. The circumstances given a rise to this incident happened in a situation, as the complainant points out. There was a heated discussion. There's a heated argument. Excuse me. Ms. Hill struck the complainant in an effort to get past her. Certainly, through her guilty plea, Ms. Hill concedes that was inappropriate behavior. But this is also behavior that is not similar to somebody who is at risk of being an abuser in future relationships. Therefore, the treatment that is being recommended, which we agree would be appropriate for Ms. Hill, can certainly be supervised under HIDA. Any failure of probation conditions under HIDA has the same consequences as a failure of probation on a public record. And so there's certainly no reason why HIDA is not appropriate in this matter. And so therefore, Your Honor, we do request that you honor the recommendation for HIDA as it was presented by the Assistant Prosecuting Attorney and as was conceded by the complainant, Your Honor. Thank you.
Thank you. I've had an opportunity to review the pre-sentence report, the recommendation of probation. I've heard the statement by the victim. Does your client wish to make a statement at all?
She does not, Your Honor.
Okay. The pre-sentence report indicates that the defendant scored a moderate high risk and levels that would indicate that she needs some supervision. This is an incident of domestic assault, and I recognize there's been a statement by the victim about how the victim believes the court should move forward, but those beliefs are not what the court is required to follow holistically. I can take it into consideration, but there's been plenty of times where, and I have one recently actually, where I've had a victim come before me and tearfully, after being assaulted by someone they were in a romantic relationship with, and tell me that they did not want a no contact order, and tell me they didn't believe that this person was a bad person, and this person is the only person that they have, and ask for me to remove the no contact order, even during a probation setting, and not even a month later, there are new charges of assault on that same victim. So these are the things that I have to take into consideration when making my ruling on sentencing. I can't grant what the alleged victim or the victim at this point is requesting. The victim didn't even appear herself today to tell me this herself, so that I can make an assessment of her demeanor and her veracity and her energy about the statement. It's a statement that was provided in writing to the prosecution for the prosecution to read. And as the prosecution has indicated on the record, the demeanor and the tone of the victim has changed since the time that she spoke to the victim just about a month or so ago, before issuing an offer. This is a situation where it's apparent per the reports, it's not the first time charge like this, or the defendant has been charged with something similar to this. So we have a situation where, although there was some period of time between those two instances, we have an issue of whether or not this could become a pattern of behavior. Having a heated discussion does not give or grant the right for you to put your hands on someone. You don't even get to put your hands on someone if you're alleging that you're doing it so that you can get by them. Although the allegations were not that she put her hands on someone so that she can get past them. The allegations were a little bit more substantial than that. Nonetheless, I do believe that a term of probation is warranted. I do believe that Ms. Hill needs some programming and some counseling. I would hope if what the victim is stating about Ms. Hill's emotional and mental state are true, that Ms. Hill is already engaging in some therapy, but I've not heard that from you today, Mr. Nagel, that she's already engaged in some of that, and none of that's been indicated in a report from the probation that she's already seeking or currently engaged, I should say, in some counseling or services to address her emotional and mental state. If that's the case, then wonderful, because she's going to need to provide that proof to the probation department. Otherwise, I'm going to order that while on a term of probation, she gets some counseling and provides evidence of that to probation. I'm going to sentence to a term of 12 months probation. While on probation, there's a $30 per month oversight fee that Ms. Hill is responsible for. I'm going to continue the no contact order with the victim in this matter. Okay, I misspoke. It does say that she's currently in therapy twice a month at Great Lakes Psychology. Are you still there, Ms. Hill? Okay,
She is, Your Honor.
very good. So you'll continue your therapy there and provide any verification probation needs as it relates to that. Looks like you've already completed anger management, so I won't order for you to recomplete that, but I will or that you complete some domestic abuse counseling, any other programming as recommended by probation. Okay, so do you have any questions so far? Okay, I need you to unmute and say it verbally.
No, I do not have any questions, Your Honor.
Thank you. Okay, and while on probation, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're not to use, purchase, or possess alcohol, marijuana, or any drugs that you do not have a valid prescription for. Do you understand that?
Yes, Your Honor.
You're not to be at any bars or nightclubs during probation. Also, you're going to be required to submit to random preliminary breath tests and or urinalysis testing, and you are responsible for the fee associated with that, okay?
Yes, Your Honor.
I'm going to grant the request for HYTA. As to fines and costs, there's a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost that will also be assessed. 12 months of probation will amount to $360. Also assessing a $200 fine. For a total of $685. There was no restitution in this matter, correct?
Correct.
Okay, so that's about $57 a month, okay? Do you have any questions about your fines and costs?
No, Your Honor.
Probation advice and rights. Okay, lastly, I have here an advice of rights for a probation early discharge. It states here that you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crime, and stalking offenses, or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights. You have the right to request an early discharge from probation once you have completed half the original term ordered by the judge. You may request an early discharge from probation after meeting the following conditions. A, you have completed all the required probation programming, and B, you have not violated the probation requirements within the last or the 90 days preceding your request. If a hearing is scheduled, you have the right to hire or retain an attorney to represent you. You do not have the right to court-appointed counsel for a hearing to address a request for early discharge from probation. Lastly, you may make your request for early discharge by completing a notice regarding eligibility for early discharge, also called the MC 512, and that's located on the court website. You are, however, on probation for one count of domestic violence, so you would not be eligible to make a request for early discharge. Do you have any questions?
No, Your Honor.
Any additional matters for the record?
Nothing from the people.
Nothing further from the defense. Thank you, Your Honor.
Thank you. Good luck, Ms. Hill.
Thank you.
You're welcome.
Good morning. Who just joined on the iPhone? Sir, can you hear me?
Yes,
What's your name?
Dennis Costello.
Good morning. Who else is on the iPhone?
T. McCullough.
Huh?
Good morning, Miss Patrick.
Good morning.
Which case are you here for, ma'am?
I am here for, hold on a second, let me get my camera. I am here for T. McCullough. I have not filed an appearance yet. I was recently retained on that case.
Okay. Did you need to speak with Mr. McCullough?
No, well, yeah, if you could put us in a breakout room, that would be awesome. Thank you.
Is he already in there?
Good morning. Who's on the device identified as Cricket?
I'm sorry, was I muted?
Yes. What's your name?
Tracy Walter?
Thank you.
Nick, if I could get a breakout room with Mr. Costello, I'd appreciate it. Thank you, sir.
Nagel, you can just return to your current breakout room. I'll just add him there.
Got it. Thank you.
Ms. Patrick?
Yes, Your Honor.
How are you?
I'm good today. How are you?
I'm doing pretty good. Are you looking for a new date on McCullough?
Well, that would probably be a good idea because I have not received a discovery yet, and I haven't filed an appearance. I was recently retained. But I do know that we're going to probably leave this on for trial, but I will leave it to the court's discretion as to how to proceed today.
Okay, we can set it for final pretrial and then give you both a final pretrial and jury trial date. That'll give you time to get a substitution filed and get discovery.
Okay, that works.
Do final pretrial July 26th. Does July 26th for a final pretrial work for you?
Let me take a look. I know that I have a trial. Yeah, I have a trial that week in the circuit court.
Okay. August 2nd. Is August 2nd gonna work?
Yes, at what time?
Final pretrials at 8 o'clock in the morning in person at the court,
Okay.
and then jury trial. August 30th. Does August 30th work for a jury trial?
Hold on just a second. August 30th. Yes, August 30th.
Okay, we'll do both those at this time.
Okay, sounds good.
All right, thank you.
Thank you so much. Have a good day.
You too. Mr. McCullough, you're free to go. Mr. Nagel, you're here on Costello.
Yes, Your Honor.
Mr. Costello, we need your fingerprints. Can you unmute your device, Mr. Costello? Can you unmute your device?
Just to make you aware, Your Honor, Mr. Costello's is hard of hearing.
Is he in the building? Is Mr.
There you go.
Costello here? Oh, no, I wondered if he was in the building. Mr. Costello, we need your fingerprints.
Okay.
When can you get them done?
I just need to come up to the court to do it.
Yes, you'll come up to the first floor of the building that the court is in. You'll go to the police department so they can fingerprint you.
Okay. As soon as I can find a ride.
On the record in the matter of the people of the state of Michigan versus Dennis Joseph Costello, file number 22-01022, council appearance.
Good morning, Your Honor. Andrea Lacey, appearing on behalf of the people.
Good morning, Your Honor. Matt Nagel on behalf of Mr. Costello, both of us appearing over Zoom.
Thank you. Today's date that was set for a pre-trial. Last time we were here, this matter was adjourned so that the assessment can be completed. Has the assessment been completed?
Yes, Your Honor, we have an assessment done by Catholic Charities. I've had an opportunity to look it over. I have not shared it yet with the prosecuting attorney. But in light of the assessment and after talking to Mr. Costello and then speaking briefly with Ms. Lacey, we are going to ask for another adjournment to see if we can get Mr. Costello qualified for sobriety court with 54B.
Okay, I'm gonna set a pretrial date. It's gonna be in person because I need his fingerprints.
Understood, Your Honor.
In 2 weeks.
Could we get it 30 days, Your Honor? It's a logistical issue with Mr. Costello living in Jackson. I just want to make sure we have as much time to move him around as possible.
It's gonna have to be August 30th. At 9:30.
August 30th at 9:30 and in person. We can do that, Your Honor. Thank you, Your Honor.
Thank you. Do you have any additional matters for the record?
Nothing for the people.
Nothing further from the defense, Your Honor. Thank you.
Thank you. You're all set, Mr. Costello.
Okay,
Are
thank
you
you.
ready on this, Advalter?
Abfolter, Warren, and Bose.
Okay, we're on the record in the matter of the people of the state of Michigan versus Tracy Sue Abfalter, file number 18-06293 and file number 22-01102. Council appearance.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people. And Assistant Public Defender Sarah Donnelly on behalf of the defendant Tracy Abfolter, who is appearing by video.
Today's date set for three trials on both matters. How are we proceeding?
Your Honor, at this time, I believe that we are working on a global resolution with her, a case out in 55th District Court. It does look like she might be getting screened for 54B drug court on that file. So at this time, we'd just be asking for probably 30-day adjournment to see what happens there.
August 30th at 9:30. August 30th at 9:30. Any additional matters for the record?
Nothing for the people. None for defense. Thank you.
Okay, you're all set for today, Ms. Abfalter.
Thank you.
You're welcome.
Have a good day.
Thank you.
How do I don't know. Where's it? Stop video.
Okay, we're on the record in the matter of the people of the state of Michigan versus Alicia Marie Warren, file number 22-00132. Council appearance.
Morning, Your Honor. Andrea Lacey appearing on behalf of the people. And Assistant Public Defender Sarah Donnelly on behalf of the defendant Alicia Warren, who is appearing by video.
Okay, today's date that was set for a pretrial. It's like we were here last. There was a new felony pending. How are we proceeding on this?
Your Honor, at this time, we'd like this matter to be set for a final pretrial and jury trial.
Your Honor, just if I may, there's a final pretrial already scheduled for a separate matter for Ms. Warren for next week, wherein the victims are the same. I would ask that it be set at the same time.
But I don't mind having them set at the same time.
So we can move July 19th for the final pretrial. Final pretrial will be July 19th at 8 a.m. in person at the court. what the jury trial can run together? Doesn't sound like the victim. The victim may or may not be the same, I'm not sure.
The victim in the felony matter is a baby, and the father is the victim on the original misdemeanor file. So he would be present on both days.
Okay.
Yeah.
We can't run two jury trials, so.
Right.
August 30th for jury trial at 8 o'clock in the morning in person. Do you have any questions today, Ms. Warren?
No.
Any additional matters for the record?
Nothing for the people here. None for defense, thank you.
They're all set for today, Ms. Warren.
Thank you.
You're welcome.
Have a good day.
Same to you. Tella Mallet, Janaya Terry.
Now that I am ready to, that's just setting for a final pre-trial and jury trial. Terry, I need to speak to him.
Okay, sounds good.
I feel like so we have Bose too.
So we do have those?
Bose, I think he's still in the breakout room.
Oh. Mr. Rose, can you hear me?
Yes.
Thank you. We're on the record in the matter of the people of the state of Michigan versus Colin Alexander Rose, file number 22-00532 SM, and then I also have file 21-02471 FY, council appearance.
Morning, Your Honor. Andrew Lee, hearing on behalf of the people.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Colin Bose, who is appearing from Antrim County Jail.
Today's date that was set for pretrial. There's also a probation violation in the felony file. How are we proceeding?
On the new file, I know that he has multiple cases with the state prosecutors. I'm not sure they're trying to seek some global resolution. I know that he is in custody awaiting sentencing in circuit court until at the end of August. So at this time, Your Honor, I would have set for a final pretrial and jury trial.
We can do a final pretrial July 26th. Final pretrial will be July 26th at 8 a.m. And we can do a jury trial August 30th. Jury trial will be August 30th at 8 a.m. Do you have any questions today, Mr. Rose?
No.
Any additional matters for the record?
Nothing for the people.
On that
Not on
front?
that matter, no, Your Honor.
Okay, what are we doing on the probation violation?
It's my understanding that the allegation is that he failed to report to probation. And after talking with Mr. Rose, he would like to plead guilty to that.
That's correct, Mr. Rose.
Yes.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, I do.
Okay, you can put your hand down. Mr. Rose, you were previously arraigned on the probation violation by Magistrate Milmore on June 21st. You were advised, or should have been advised, that you have the right to have a contested hearing. That hearing is scheduled for today. And you have the right to have the prosecution and the probation department put forth evidence to establish by a preponderance of the evidence that you in fact violated the terms of your probation. Do you wish to waive that hearing today and plead guilty?
Yes, I do.
anybody threatening you to get you to waive that hearing?
No,
Anybody promising you anything to get you to waive the hearing and plead guilty?
no,
Okay. Are you pleading guilty to the violation because you believe you're guilty?
yes,
Violation is that you failed to report to probation to review the orders on April 6, 2022 at 10 o'clock in the morning. States that the probation department emailed you on March 28, 2022, left, and the message was sent back due to an inaccurate information provided. It also says that the probation department contacted you on March 28th to inquire about a correct email address, but that there was no response from given to their phone call. As to that violation, how do you proceed?
guilty,
Are you want to plead guilty or not guilty?
guilty.
Okay, on a factual basis.
Thank you, Your Honor. All right, Mr. Bose, when you were sentenced, were you ordered by the court to report to probation? I'm sorry, did you say yes?
Yes,
Okay, I'm sorry, I didn't hear you. All right, then, at the time of sentencing, or, I'm sorry, let me go back. Did you report a email and phone number on the pre-sentencing report to probation?
yes, I did.
All right, and your phone number at the time it was reported, was it 313-405-0193?
Yes,
All right, now is that an accurate phone number for you?
no,
No. And did you let the court know at some point what what a better phone number would be?
I did.
Okay. All right, and then you also did you report an email of tburn200@gmail.com?
Yeah,
Is that the correct email address?
no,
Okay. You also you reported a mailing address on Rutherford, correct?
yes,
All right, and is that still an accurate mailing address?
yes,
All right, but you don't live there, correct?
no, I do not.
All right, so did you ever report to review your probation orders?
No,
All right, and have you been in custody since June 21st?
yes, I have.
Your Honor, no further questions.
Any questions from you, Ms. Lacy?
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Trying your plea to be made freely, voluntarily, and intelligently. You can proceed with allocation.
Well, thank you, Your Honor. Mr. Bose, I've explained, we went over the violation. Obviously, he doesn't dispute it. He knows what is expected of him and that the onus is on him to reach out to probation, even if he didn't receive any word. And obviously, there is indications that he did receive something in the mail. He just didn't get it. But in the end, he does agree that, it's on him to do the conditions of probation. Your Honor, at this time, he would like to be continued on probation and be given that another opportunity. Thank you.
said he has another matter pending.
He is awaiting sentencing on 2 matters before the circuit court. He's gonna be remanded until then. And then, yes, there is one more pending matter, I believe that is set, for a. His final matter, I think he did waive the preliminary exam last week, so that's going up to circuit court. There might be some sort of global resolution offered at that point. I'm not sure, but yes, he's 3 matters should be in the circuit court.
Okay, and then he has another matter before my court,
Yes.
pending.
Well, 2 matters, yeah. He has a city matter he was here for yesterday as well.
That's correct. He's already served over 30 days on this matter, to which he pled guilty to use of a self-defense spray. Even under the facts that was put on the record, I think the circumstances would indicate that him serving the 30 days I would find sufficient. So I'm gonna credit him time served and discharge him. He's got other issues that he needs to worry about. And it doesn't appear that he's a good candidate for probation, at least not at this time. My last record is that he didn't even have stable housing. He was living in his car. Okay. So I'm going to credit you time served and discharge you from probation. Okay, sir?
Yeah,
Do you have any questions?
no,
Okay, you're all set. I'll refer that he has a balance on here. Let's see what it is. Oh, you know what? Let me read that. He was never supervised. For the crime victim rights and state minimum costs to collection. Okay. So on the record in the matter, the people of the state of Michigan versus Tella Simone Mallet. 2-01416, council appearance.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Tila Mallet, who is appearing by video.
Thank you. You can hear me, Ms. Mallet?
Yes.
Okay, your attorney indicated that she would wants this set for a final pre-trial and a jury trial. I'm assuming there was no offer extended.
Correct, Your Honor. No offer at this time.
Okay. The final pre-trial is going to be Tuesday, July 26th at 8 o'clock in the morning in person at the court, okay?
Okay.
Your jury trial is going to be August 30th at 8:30 in the morning in person at the court. Do you have any questions today, ma'am?
No.
Okay. Any additional matters for the record, counsel?
Nothing for the people.
None for defense, thank you.
Okay, we'll see you on the 26th, okay, ma'am?
Okay.
Have a good one. And then you need to speak to Ms. Terry. So you see, ignore the request you're gonna get after we open the breakout room.
I'm sorry.
Ignore the request you're gonna get. I had to
Okay.
open the breakout room. Good morning. What's your name, ma'am?
Samantha Hartwig.
Okay, very good. When your attorney is available, I'll see if she needs to speak with you privately, okay? Good morning, Mr. Worthy.
Good morning.
I think you're in the wrong courtroom. I think you're supposed to be before Judge Flores.
Laura, okay, thank you. I didn't see the link there. Is the link posted in the same place?
Oh, do you have, it is posted in the same place. It should be for Flores, or I can give you his, it's all just, I can give you his Zoom ID if you have a pen.
I don't, but I can go back to the original page and pull that up though. It's under his name, correct? Okay,
Yep,
thank
it
you
should
so
be under
much.
Flores.
All right,
No
thank you.
problem. Okay, we're on the record in the matter of the people of the state of Michigan versus Janiyah Terry. File number is 22-01502. SM council appearance.
Good morning, Your Honor. Andrew Lacey appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Janiyah Terry, who is appearing by video.
Thank you. Today's the date that's set for a pre-trial. Here a couple weeks ago, so it was an offer for the defendant to plead guilty to count 2 and 3, no objection to HIDA. However, there was a supplemental discovery request made. How are we proceeding at this time?
Your Honor, I have not received a response for the supplemental discovery request, so talking it over with Ms. Lacey, we expect that we would have that request and I'd be able to, it's for body camera, so I'd be able to review it and have it ready in 2 weeks.
Your Honor, and I'm just checking now to see if I've even received it, but I don't think I have.
Okay, we'll reset this then. August 2nd at 9:30. August 2nd at 9:30. Do you have any questions, Ms. Terry? You're muted, by the way.
Can you repeat that again? I'm sorry.
Yes, your next court date will be a pretrial on August 2nd, and it's gonna be at 9:30.
Okay.
Do you have any questions?
No.
Any additional matters?
Nothing from the people. Not for defense, thank you.
Okay, you're all set for today, ma'am.
Okay, thanks.
Ms. Hartwick is here. And then, did you need us to have them bring proof either on Polycom or?
Yes, if it's possible to get him on the
Polycom?
Zoom,
Okay,
or,
let's see.
yeah, so that I can talk to him. Ms. Hart, if I just get a brief breakout room with her.
Okay.
Or no, sorry.
Ms. Donnelly, is she coming back already? Oh, you finished with Ms. Hartwick?
I am,
Okay.
and I'm ready for divine patron. But, I mean, yeah.
Okay, Ms. Hardwick,
Mm-hmm.
can you hear me, Ms. Hardwick?
Yes.
From the record in the matter, the people of the state of Michigan versus Samantha Hartwick, file number 21-02613 SM. Appearance, please.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Samantha Hartwig, who is appearing from Indian County Jail.
Today is the day set for a pre-trial. We adjourn this to allow there to be screened for drug court. What's the process? What's the update on that?
I'm not exactly sure on the process for drug court, Your Honor. This is another Mr. Keithley's case. So as I'm reviewing the file, it seems like they've been waiting to make a global resolution in circuit court. She's got one more felony matter pending in, I think it got bound over from 54B up to circuit court. So it's my understanding that with all of those cases now in circuit court, that they'll be working on some sort of global resolution. So in this case, I would just be asking 30 days to see how that process goes.
August 30th at 9:30. Do you have any questions today, Ms. Hartwig?
No, I don't.
Okay, you're all set. Thank you.
Thank you.
We're on the record in the matter of the people of the state of Michigan versus Devon Cager, file number is 22-01689. Mr. Cager, can you
Yes,
hear me?
yes, ma'am, I
Okay.
can.
Okay, in a previous file, you had a issue in which the court had to grant your request to remove Ms. Donnelly from your case. She is assigned to represent you on this matter. She's represented to the court that you all have worked out your differences. Are you moving forward with Ms. Donnelly as your representative today?
Yes, ma'am, I will.
Okay, appearances for the record.
Good morning, Your Honor. Andrea Lacey, appearing on behalf of the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant, Devon Cager, who is appearing by video.
Thank you. Today's the date set for a free trial. Was there an offer on this?
No, Your Honor, not at this time.
Okay, so you want a final pre-trial and then jury trial?
Yes, Your Honor.
Final pre-trial, July 26th at 8. Final pre-trial will be July 26th at 8 a.m. in person at the court. Trial will be August 30th. When is the pre-trial to be held? Jury trial is gonna be August 30th at 8 a.m.
Okay.
Do you have any questions?
No, ma'am, or is it by Zoom or in person?
They're both in person.
Okay.
Okay, any additional matters for the record?
Nothing for the people.
No,
None for
no.
defense, thank you.
Okay, you're all set, Mr. Cager. We'll see you on July 26th.
Okay.
Thank you. Good
Bye-bye.
morning in the jail. Can you hear me?
Good morning, Your Honor.
Okay, do you have Mr. McClure?
I do.
Okay. Mr. McClure, I think your attorney needs to speak to you, so one moment.
Yes, ma'am.
Are we ready to go on record? On the record in the matter of the people of the state of Michigan versus Selena Smith, file number 21-01332 SM. Council appearances.
Good morning, Your Honor. Angela Lee, appearing on behalf of the people.
Jeffrey Rossi, appearing on behalf of Selena Smith, who is standing to my right.
How are you, Ms. Smith?
I'm good. How are you?
I'm good, thank you. Today's the date that was set for a pretrial. Was there an offer extended on this?
No, Your Honor, there's not. And I'll place on the record what I would ask. There's no offer in this matter because this matter could have been a felony. And the victim has requested that I review it to make sure that it should not be a felony. Right now, at this time, I have not made that determination. However, what I would ask, because she is charged with a domestic violence charge that she plead as charged, I would not object to sentencing under 76948, and then she would also have to agree to pay restitution as the victim has amassed a number of hospital bills due to a broken knee and a broken foot.
Mr. Rossi.
Your Honor, I think Ms. Smith would like to discuss an issue with the court at this point.
Ms. Smith? You want to discuss an issue with the court? I don't know.
Like you spoke to me about one thing.
I had talked to the public defender office about getting a new public defender.
Okay, what did the public defender's office say?
They said they were gonna assign me one, but then nothing happened.
Okay. Without disclosing to me any confidential privileged information, why is it that you're requesting another public defender? Are you asserting that he's not giving you effective assistance of counsel?
We talked one time and I was trying to tell him like everything that happened before that incident, like that incident that took place. And, you know, it just seemed like he really didn't like care too much of what I had to say. So it didn't make me feel comfortable listening to me. Because I'm not from Illinois, I'm not from Michigan, I'm from Illinois. So I'm here. Found myself and I just want to make sure I'm getting the right.
Okay. I'm not gathering at this point that there's been an ineffective assistance of counsel or that there's been a breakdown. She didn't even seem to know what you wanted her to address with the court.
I will say this, Your Honor, that I have spoken to her without disclosing what we have discussed. I believe there is a breakdown in communication.
Okay, I don't, and so I'm not going to grant any motion to withdraw. If the public defender's office would like to reappoint, that's on them. Looks like this matter, she wasn't even arraigned until June 25th, so it has only been 2 weeks. It sounds like she spoke to you one time.
Well, we've spoken more than one time.
Well, she's only recalling that you spoke
Correct,
one time.
correct.
Whether or not that conversation or communication was heated, it probably was. It's a criminal matter. I'm sure you should be used to having heated discussions with people that you represent in a criminal matter. And doesn't always go as smoothly as we want it to do, but but it does not appear that there's a breakdown in communication that is irreparable at this point. So today is the date set for a pretrial. There is no offer typically. We would set this for a final pretrial. If between now and then the public defender's office believes that they need to appoint someone, and I'm assuming there's a reason why there's conflict counsel.
Correct. And I'm not privy to that. I'll try and find out more information. We had discussed, and I do not know whether my client remembers this, is that we were going to set this for final pretrial today.
We'll set it for final pretrial, and then if for some reason you get information before we do that there's going to be a reappointment, if you can just email us so that we can reset it and allow time for there to be exchange of discovery with whoever the new attorney is. But final pretrial, July 26th. Does that work for you, Mr. Rothstein?
Does, Your Honor.
July 26th at 8 o'clock in the morning in person at the court. Jury trial. September 6th at 8 a.m. That works. That's the date after Labor Day.
I have a delayed sentence via Zoom at 9:30 with 54B. Yeah, let's just leave it at that. I can probably get that covered.
Okay. Also, if it's via Zoom, you can do that from here while we're calling the jury in anyway. So
Correct.
we'll do September 6th for a jury trial date. Do you have any questions today?
I just heard two different dates, so.
One is a final pretrial. And so by then we'll know if you're going to get a new attorney or not from the public defender's office, or if there's been a change in the offer, we'll know about that by then as well. And then if we are going to proceed to a jury trial at this time, it's set for September 6th.
Okay, so next court date, we're gonna see if it's gonna be set for the December court date.
That's correct. Okay. You have any other questions? Okay, both of those court dates are at 8 o'clock in the morning in person in the court. We're going to give you a copy of the notice to appear. Any additional matters for the record?
Nothing, Your Honor. Thank you.
Thank you.
I'm gonna get help from the city docket. Luke Goodrich will do the city docket and help me out for the time being, so sorry.
Oh, okay. You ready on
So McCullis will be a final pre-trial.
Okay.
Oh,
Okay, there was no offer.
no.
Okay. Mr. Recluse, we're gonna get you a final pretrial and jury trial date. Final pretrial will be August 2nd at 8 a.m. August 2nd at 8 a.m. is your final pretrial. And jury trial will be September 6th at 8 a.m. Jury trial will be September 6th at 8 a.m. Both of those dates are in person at the court, okay, sir?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Okay, well then you're all set. Thank you.
Thank you, Your Honor.
That's all I think I have. Let's see. Have we had perfect attendance though?
Oh my gosh, well, so far, yes. No,
See?
Nope, no one said no, but the afternoon is still. That's where I didn't get a hold of.
You need to speak.
Positive energy out there, positive energy. Everyone's coming to court today.
But yeah.
We don't need to issue bench warrants.